Hi, my name is Baldev Binder, and I'm here with my colleague Raman Kaur. Today, we're going to be talking about letters of credit.
Thank you, Baldev. The Hin Leong debacle triggered a wave of litigations in Singapore. This included some cases involving letters of credit. One of these cases was a case involving Winson Oil, where Winson was not able to claim payments under letters of credit. Can you tell us a bit more about that case?
Winson Oil, I like to describe as the case of 3 R's. You have representations, you've got red flags, and then you've got recklessness. I'm going to talk about each of this in turn, but let me speak about the background to the case before I do so. So Winson involved Hin Leong organizing a pre-structured trade. Hin Leong allegedly sold goods to Trafigura onto Winson, Winson back to Hin Leong. This was pre-structured in the sense that everyone knew each other, was buying and selling from each other. What was remarkable about this case was that when Winson presented under the letters of credit, the banks, OCBC and Standard Chartered, refused to make payment for a variety of reasons, which I'll come to. And subsequently, there was litigation about this. That it turned out when Hin Leong collapsed, it turned out the judicial managers looked into the affairs of Hin Leong, and they found that the trade, this particular trade that was done, this circle that was done, was actually not legitimate in the sense that there was a separate trade for the same cargo involving Unipec. So that's what led to the litigation. The case is remarkable because, in my mind, I think it's one of these one-off cases where it's so unique in its facts. But let's now get to the 3 R's, right? So what are the representations? These is the trades involve an oil trade. So in oil trading, typically you might use a letter of indemnity. And a letter of indemnity is something you would use where you haven't got the original BL. So you instead provide this one-page document saying, cargo has been shipped pursuant to valid BLs on vessel A, B, and C, and I've got good title and I'm passing good title to my buyer. That is the nature of a letter of indemnity. But those representations were alleged to be false. So let's look at them in the Winson context. Were those representations false? That's where we go on to the red flags. The red flags in this case was really quite unique. There are several factors, I think, that led to the red flags. One of them being there was obviously no original BLs being used or being transmitted in the chain, whether at the start or eventually. There was the very concerning issue that what the judicial managers found. They found that the original BL was done with Unipec. Sorry, the original BL was given to Unipec, and there was loading documentation to corroborate that original trade. So it seemed that Unipec had done an original trade with Hin Leong, but Hin Leong then created a fictitious trade involving Trafigura, Winson, and then back to Hin Leong again. The question for the court to wrestle with is what was Winson's knowledge with this? Could it be guilty of fraud at the time it presented under the letter of credit? What were the red flags, right? So the red flags would be no original BL was used in this transaction, particularly given that all of these parties were based in Singapore. Why were there no original BLs transmitted? Why was there no loading documentation when previously there was loading documentation that was sent? There was a change in the quantity of gas oil, which is very unusual after shipment. But I think the 3 most important factors would be this. Number one, I think, and this is the most unique part about Winson Oil, at the time that Winson presented its first documents under the letter of credit to OCBC, if I recall, it presented under a vessel called Ocean Voyager. In that presentation, it presented the LOI and its invoice. The LOI said, cargo has been shipped pursuant to valid BLs on the Ocean Voyager. It also said, Winson, I've got good title and I'm passing good title to Hin Leong. That representation, when it was given to the bank, for reasons that it knows best, felt that the cargo wasn't shipped according to what Winson was saying. So what happened in that case? The bank came back and said, I'm sorry, Winson, I don't think this cargo was shipped pursuant to valid BLs on this shipment. So what did Winson do? I mean, an ordinary person would say, oh my God, you're saying this wasn't shipped. Let me go and check it. Let me go and find out. Winson didn't do that at all. I mean, from what we read in the case, what Winson did is that it took another trade involving a different vessel, the Ocean Taipan, that was meant to be given to Standard Chartered to be presented. It then gave it to OCBC, and then it swapped the OCBC docs with Standard Chartered. That to me is highly, highly suspect, particularly when a bank has come back under a letter of credit to say, I don't think this trade is legit. That's effectively what the bank was saying. And then to then say, okay, we'll just swap it around. That is highly dubious behavior. The second point I think that I find was quite influential in this case would be after the fact. After the fact, when Hin Leong collapsed, I think the banks and obviously Winson were talking about how to deal with this cargo. They obviously didn't want to take a risk on Hin Leong when it was collapsing or going to collapse. And so the bank spoke to Winson and say, I think you might need to buy back this cargo or sell it to a third party. And at that stage, this was after the presentation of the LOI, yeah? At that stage, Winson turns around and says, I got to check if we've got good title, or I've got to check if we've got clean title. I think that's the phrase, if we've got clean title to that cargo. So I want to stop there because just yesterday, I use it loosely, just yesterday, Winson presented under the LOI, I've got good title and I'm passing good title to Hin Leong. The next day when the bank shows up and says, I think you need to buy back the cargo, Winson says, oh, wow, I need to go back and check if I've got clean title in the first place. And that, I think that is a massive red flag. The last point I'll talk about is this notion of Winson issuing a letter of indemnity saying, I've got good title. From what we read in the case, it issued that letter of indemnity before it received the follow-up letter of indemnity or the earlier letter of indemnity from its supplier, TREF. So if TREF hadn't given good title to Winson, how was Winson alleging that he had good title to give to Hin Leong? So put all this together, you've got some screaming red flags put out there. Now let's talk about recklessness. The representations were false. There were red flags. Let's look at the recklessness element. Was Winson reckless? Could they be guilty of fraud under the presentation? And the point about recklessness is that, let's take a step back. Fraud. What constitutes fraud? Fraud means you either have actual knowledge that something isn't true, or you have no honest belief whether something is true. The third thing would be where you are recklessly indifferent as to the truth or falsity of a statement. And that's where Winson was, recklessly indifferent. The notion of recklessness, people often think of it as alongside negligence, that it's just an objective standard. But that's not how recklessness is used in the fraud sense. It is a subjective standard. The definition used in court is when a person doesn't have certainty of information as to the state of affairs of the truth, but yet chooses not to take steps to isolate its mind from finding out the truth. And I think that is where Winson found itself in that position. For example, we go back to the facts again. Winson was told this cargo wasn't shipped pursuant to valid BLs. What did it do? It isolated its mind and said, I'm just going to swap the cargo with something else. Winson was faced with that challenge. I mean, it could have gone back to Hin Leong, who organized this trade, and say, Hin Leong, what's going on? Where are the original BLs? Is this a legit trade? That all of these sort of shows that what Winson was doing was that they didn't have enough information and they chose not to go and find that information. They were already appraised of a situation that looked dubious to them. They you can even call it half suspected, I suppose. But they chose to then take steps to not find out the truth. And that is recklessness. And that's why I think they were found to be guilty of fraud, such that the bank had a remarkable position of not having to pay under a letter of credit. You have to remember that in Winson Oil, the judge decided that there was no shipment as represented under the letters of indemnity. And because that was the case, and it was done so recklessly, he didn't need to decide on the issue of sham. But sham argument, that hasn't stopped lawyers from trying the sham argument. It's been tried subsequently in a Glencore case, and most recently with China Aviation, with less successful results once again. So Raman, maybe you can tell us a bit more about China Aviation Oil, the case involving BCP and China Aviation.
Certainly, Baldev. So BCP and China Aviation was a case about an oil trade financed by the bank, BCP. BCP provided financing to Zenrock to purchase an oil cargo from China Aviation under a letter of credit. Now, as is usual in oil trading, the letter of credit allowed for payment against the presentation of a payment letter of indemnity, an LOI, instead of the usual, which is the presentation of the actual shipping documents. In this case, China Aviation presented an LOI, And in that LOI, it made certain representations to the bank, which are also fairly common. One of these representations was about the existence, validity, and authenticity of the original shipping documents. Now, the bank paid against the presentation of this LOI and wasn't reimbursed by Zenrock. So it turned around to China Aviation for recovery. And the basis on which it did so was by arguing that the representations that China Aviation made in the LOI were fraudulent. One of BCP's key arguments was that China Aviation had made a fraudulent misrepresentation in its LOI as to the existence, validity, and authenticity of the shipping documents. And a key angle on the basis of which it pursued this argument was that the sale from China Aviation to Zenrock was a sham.
So a sham transaction, how did that come about?
Yeah, so BCP argued that China Aviation's sale to Zenrock was a sham because the oil was in fact being traded in a separate parallel chain. Petco sold the oil to Zenrock and Zenrock sold it on to Petrolimex. And BCP argued that, since the oil was being traded by separate parties altogether, China Aviation's sale to Zenrock must be a sham. It couldn't have been a genuine sale. Now, the High Court did not buy that argument. It found that the two sales chains were not, in fact, mutually exclusive. Petrolimex sold to Zenrock, and before Zenrock sold on to Petco sold to Zenrock, and before Zenrock sold to Petrolimex, it created an other chain which was equally legitimate. It was a circle.
Right, okay.
So Zenrock sold the cargo to an intermediate seller. That started the other chain. And that other chain ended with Zenrock buying the cargo back from China Aviation.
Right. So just because there were two trades doesn't mean that it's necessarily one trade is necessarily fake.
Absolutely.
The circle could be part of the original linear trade.
Exactly. That's exactly right.
So the court is saying just because there are two trades doesn't mean one's fake. But surely the court also would look at the actions of China Aviation in the same way that Winson was looked at as to whether it was reckless, whether it actually believed the trade was real or not. Was there the similar sort of inquiry with China Aviation?
Yes, definitely. The court also looked at China Aviation's other conduct. China Aviation had conducted due diligence on this transaction, both on the purchase leg and the sale leg. It had negotiated the terms, conducted and entered into deal recaps, conducted all the usual operational steps concerning vessel nomination, appointment of an inspector to witness the loading of the cargo, to inspect its quality and quantity. And all of these things are what you would find in a genuine oil sale. And taking all these considerations in the round, and also noting the fact that there was a legitimate commercial reason for the two parallel chains, which is for Zenrock to avail further financing for an additional, I believe, 35 days, the court concluded that the sale from China Aviation to Zenrock wasn't sham.
It fit within the chain, I suppose.
In the round, the sham theory didn't stick, and this finding was not challenged on appeal as well.